Late Friday, the U.S. Supreme Court pressed pause on a federal court's decision that restored critical safeguards to the dangerous abortion pill. The decision resulted from Alliance Defending Freedom's lawsuit on behalf of Alliance for Hippocratic Medicine and several other clients, which continues in the lower courts. Joining me now to break down the takeaways from the court's decision Friday night is Alliance Defending Freedom Senior Counsel Erik Baptist, who has worked tirelessly on this case. Erik, welcome to Washington Watch.
Thank you for having me.
So let's start first by explaining the court's actions from Friday.
The court essentially hit the pause button on our victories from the lower courts, both at the district court level and the Court of Appeals at the Fifth Circuit. We had prevailed largely on all of our claims, and the Supreme Court came in without any comment or opinion and hit the pause button on that and said, well, pause on the effect of your victories until the Supreme Court has a second chance to review the merits of our case.
So this is no definitive decision, just saying we're going to let this go through the process and we're not going to short circuit the process. We're going to allow the policy to stay in place that this administration has put forward, and we're going to let the courts decide whether or not they breach their boundaries.
That's exactly what the court did here. Just kind of hit the pause on this because what we are asking is relatively ambitious in the sense of we're asking to take this drug off the marketplace and restore previous safeguards. And maybe that was too much too soon for the court, and they just wanted to slow things down and go through the normal process.
But Erik, if I'm not mistaken, this is on an expedited track. So the court is going to move expeditiously on this. We're not talking a year, we're not talking 2 years. This is something that's going to happen pretty soon.
That's correct. This still maintains that we are on a very expedited schedule. There's no rest for the weary, unfortunately. And we're going to be in front of the Fifth Circuit Court of Appeals on May 17th. So this is going to get fully briefed up in the next few weeks. And then they're going to hear our case on the merits. Prior appeals were done on the emergency motions by the government. So this is the first time we're going to actually have the merits being heard by both the Fifth Circuit and maybe one day the Supreme Court.
So let's talk about that for just a moment. Then we're going to get into the merits of the case. So the 17th of May, the Fifth Circuit hears the arguments in this case. What happens next?
Well, then we're going to wait for the court to decide, and that could be a matter of a month or 2 or 3. But because we've sought expedited review, we hope sometime this summer the Fifth Circuit will come back with its opinion and favorable in support of our claims.
Then you expect it to be appealed. I would think the Fifth Circuit most likely is going to see the merits in your arguments. I mean, that's speculation on my part, but knowing some of the justices there, the judges there. So then it would most likely end up back before the Supreme Court?
That's exactly right. If we prevail at the Fifth Circuit, the Biden administration and the FDA, they're going to go right back to the Supreme Court and ask for relief.
Okay, so now, Erik, let's get into the merits. The elements of your lawsuit, let's talk about those. What were your major objections with this policy that the Biden administration put forth?
From day one, the FDA has violated federal laws and even the agency's own regulations. So we have asked the court to hold the FDA accountable for failing to follow the law when approving these drugs back in the year 2000. To the subsequent actions where they took away basic protections for women and girls who do take these drugs. From the beginning, the FDA considered pregnancy as an illness and argued that chemical abortion drugs provide a meaningful therapeutic benefit. We know that's not true, but that was the only way they could justify their approval in 2000 to use their fast track approval authority. So that, again, the district court agreed with us on this claim. But also Congress, when it delegated its authority to the FDA to be the nation's drug gatekeeper, it gave specific instructions to the FDA on how to approve a new drug if it is to approve it. And basically it said you need to study the safety and effectiveness of a drug under the approved conditions of use, as directed by the label. That is something the FDA has not done for the last 2 decades and change. That means they have reviewed a protocol that's never been a part of the approved regimen. In particular, ultrasounds. They've never required ultrasounds, but almost all of their studies include that basic safety protocol to identify life-threatening complications, to confirm gestational age, because as the woman gets farther along with her baby's gestational age, the more likely there will be complications. So we are asking the courts to, again, hold the FDA accountable for failing to follow the law here, because when agencies fail to follow the law, what happens? serious consequences flow,
Right.
in particular harms to women and girls.
To that point about the gestational age, this abortion pill is designed for the first trimester. I mean, this is for the early stages of pregnancy and can create significant health repercussions for the mother if it is taken at a different time or at a later stage. So that's one reason there was a requirement that they have interaction with a medical provider to determine exactly where they are in pregnancy. Isn't that correct?
That's correct. It was the Biden administration said took the doctor, took the healthcare provider out of the equation and said, you don't need to meet with that doctor to be screened for these type of complications or gestational age. You can just do this by phone, by computer, and obtain these drugs. That's reckless, dangerous, and frankly illegal.
And I would just, one final point I would make on that, Eric, is that in 2000, these were still a minority of the abortions being performed in this country by this pill. Now they're the majority. So this is even more significant in terms of its health implications for women.
Exactly right. Now, over 50% of abortions are committed by chemical means. And what we've seen correspond with that is an escalation by 500% of emergency room visits by women after abortions, in particular because of the chemical abortion drug.
All right, Erik Baptist, I want to thank you for taking time out of your very busy schedule as you prepare for that May 17th date. And we're going to encourage our folks to pray for you as you make those arguments before the Fifth Circuit. And as always, we appreciate all that the Alliance Defending Freedom does on behalf of our freedoms.
Thank you very much for your prayers and support.